Hello and welcome to this episode of The Big Picture. Big Picture, Big Conversations. This is where humor meets depth. Now, my name is Tom Mukwana. I'm your co-host for the day. No, Shish Nimezoya. I'm your host for the day. Justine is not around, but she's replaced by a friend of hers today, one of the guests that we have on set. But the conversation for today is about copyright law in Kenya. For that, we have three guests who are on every side of this business. We have someone who writes, someone who sings, and someone who manages the business of art in Kenya. The conversation today is around one legislation, the Copyright Act, or legislation that was introduced by KECOBO, the Kenya Copyright Board. We have a representative of KECOBO here with us today. He'll be telling us why this law could be a huge shift in how artists profit from their art in Kenya. He'll tell us how this will affect the industry, what artists will get paid from, and why you should care about this conversation. Now, to those guests. To my immediate left is Moriasi Omambia. He's the General Counsel and Head of Business Affairs at Sauti Sol Group Limited. He's also a top 40 under 40 men, class of 2023. Asante sana for coming here. Bwana Moriasi. And then Meran Randa. This is the friend of Justine that I was speaking about. Meran is a Kenyan writer, researcher, and historian and filmmaker with multidisciplinary background. She provides commentary on social issues with a special focus on Kenyan politics and culture, and is part of the research team for Wangari Maathai production being put together by Too Early for Birds. She writes plays, she researches them, and writes a bunch of articles and knows a ton of history about this subject and more. Asante Meran for coming.
Thank you for having me.
And finally, Dan Aceda, a board member at the Kenya Copyright Board. He's an award-winning musician and a performing artist, and the self-proclaimed His Royal Highness, Crown Prince of Benga Chief, also an ambassador of #Big Creative Movement in Kenya.
Yeah.
Asante Dan for coming.
Thank you.
Dan, to start this entire conversation, the first thing that I saw was a video that you did on exactly what we're discussing today. So if we can, please let's run that clip.
Ladies and gentlemen, I'm here to announce today probably the most important consequential moment of our time as creators today in Kenya. The Kenya Copyright Board finally published the draft Copyright Amendment Bill 2026, which seeks to replace the current Copyright Act and hopefully set us up as an industry for the next 20, 30, maybe 40 years. Let me give you a little bit of a history. The first time the Copyright Act was written in Kenya, it was done so in 1966. It's done by this guy. The only thing he did was to domesticate a law that existed in the UK. And so that law didn't help anybody in the 60s, the 70s or 80s to deal with the piracy and content protection issues that were emerging that time. By the time we got to the 80s, piracy was such a huge issue that this industry was technically insolvent. No money. So when we get to the late 90s, Foxy Pressure and a bunch of other artists, Kinawaire, Ted Josiah, Nazizi, they do a lot of activism, and at some point, apparently, Foxy Pressure was living at the Attorney General's office. CMOS Wako finally moves a new bill to replace that law in 2001. It becomes operationalized in 2003, and then unfortunately, there's radio silence. And for about 10 years, nobody talks about the Copyright Act. And in that time, how we need to protect our work changes again, and suddenly the law is obsolete. Even though there have been many attempts to make minor amendments to improve the law, right now that law is too old to serve us for the future that we want to achieve as creators who are working in IP in Kenya. Now we have the wonderful opportunity to replace the entire law once again. This will be the first time under this constitution that this is being done. It's being done by the Kenya Copyright Board. They've just published a draft of it on the website. Please check it out. I encourage everybody who works in any IP-related craft at the moment, please engage with this bill. Let's talk. Let's try and find a way to make a law that's going to serve us today and also serve us 30, 40, maybe 50 years to come. Foxy Pressure stood up for this industry. It's our turn right now. We can make something that matters.
Sorry, that's the Copyright and Related Rights Bill of 2026. Pole Dan Mazo Senior.
Yeah.
I'll start with you, Dan. Why do we need this now?
The summary is that we've been operating, everybody, not just musicians, but everybody who's operating in any IP-related field, we've been operating in under a very, very old law. And the law was written, the bulk of the law was written in the 90s. And the copyright or IP infringement situation that was existing at that time in the writing the law does not exist today. Today, we've got a totally different operating structure. And so there are things that you need in terms of how to protect your work that were just not possible because the law never anticipated that problem. So for instance, the many ways that the internet can affect your work, the law never anticipated that. We tried to fix it in the mid-2010s with an amendment, but even that amendment didn't go far enough. It didn't have the correct underlying basis to do it. So it's been like patchwork to try and fix things. And I think it's got to the point where it's important that we rewrite the law, knowing what we know now. Also, remember, in between, the constitution changed. So things are different. So we also have to align now to the constitution better. And then to try and anticipate what's going to happen in the next 5-10 years, where technology is going, and to make sure that this industry is ready for that.
Yeah. Meran, what's the history of copyright and intellectual property in Kenya in general?
I would say, okay, the first law he's talking about, the one that was made pre-independence, was made because we needed to have something. They were artists and they needed to have a law. So it didn't really take into account what these artists needed, what kind of artists they were, what was happening at the time. It took us coming into the 2000s, I think, then artists started agitating again for them to have a law that, how can I say, a law that takes into account what they have, the things that affect them. They need this, they need that, times are changing. That law was made for like cassette tapes and video cassettes, and now we have streaming platforms. So just needed to be updated to what, as he said.
As he said. Moriasi, you at some point, or you do actually, I don't know if the group is still the same way, but you are general counsel and head of business affairs at Sauti Group Limited. I'm a rap fan, which means I hear about masters. I'm owning my masters. I'm not enslaved anymore, and royalties. What does that mean from an artist's point of view? Because those are very crucial terms to this entire discussion.
So, owning your masters is owning the right to commercialize your music. So the right of commercialization, and owning the right to make decisions and directly earn from the sale or streaming, like now, the streaming of your music, right? And lastly, owning the right to license your music in a situation where, let's say you wanted to be part of a movie, synchronization and such, owning that exclusive right, owning the exclusive right to get to do that. So that's what masters are. So on the hip hop side, it's not just, it happens everywhere, right? And I think the more recent global case was Taylor Swift, and how she had to rewrite all her music so she can own the masters to her music. How it works in layman's term is he who pays for the means of production owns the master. So in many situations you find when an artist is starting out, that's when they sometimes make their best music, because you want to get out of the situation they're in. And then your best music, because you didn't have the money to produce it, is, owned by a label or the producer who produced the music, right?
Is it the same thing as royalties?
No. Royalties is what you earn from the, in this situation, streaming of music. So you have your master royalties and your publishing royalty.
Okay.
Yeah.
In the Kenyan context, how does this then apply, if we were to take, for instance, Sauti Sol, how does this apply to their music?
So apart from one album, we've been independent. Well, they've been independent. And so in that situation, we owned all our masters, who were fortunate enough to be in a position where we could administer the distribution of that music ourselves, and we got the right partners to make sure that the music was in the right spaces. So the master royalty came straight to us. In the beginning, when it came to publishing, in terms of public performance royalties, radio plays in Kenya and outside the country, we, of course, worked with, that time there were 3 separate, MCSK, Prisk and Camp. And there was collections from that side. But outside, we did have a publisher. We severed that relationship, and this went directly to businesses that help collect royalties on behalf of artists from other sides. So as we grew bigger, we got more access to direct relationships, to PROs like in Europe and the US.
Okay.
Yeah.
Dan, Sauti Sol is a major brand.
Yeah.
For an artist who's just starting, for an artist who's established here in the country, how do they interact with CMOs or this copyright or intellectual rights space?
So I think it's important that we put the layers. So first of all, you make a piece of music, the music belongs to you. So the first right that you have, what Moriasi was talking about, is your master right. You control how you distribute this. So that one is 100%, and your primary revenue comes from controlling of your master. So you sell your music or you stream your music or however you do it, perform your music, that's your primary revenue. Your secondary revenue comes from when a third party plays your music where you were not involved. So for instance, a radio station plays your music, right? You are not involved. The radio is playing to also another group of people that you don't control.
Yeah.
So that situation is called public performance, where your music has been played to the members of the public, but you are not involved. Yeah. That's where you're owed a royalty. Okay. Now, because we don't know whose music the radio station is going to play, it's not possible for every artist to collect directly from the radio station.
Because there's no data.
There is data, but it's the logistics. If the radio station was to pay every single artist directly, the logistics would be impossible. So how the globe has evolved to fix this is to say, we are going to have a collective management organization, which is going to collect on behalf of everybody. And then based on the plays and popularity of the song, we will pay out the royalties to every person who's been played by the station. That's the concept. So that's why you have CMOs, collective management organizations. In Kenya, we've had a difficult history with the CMOs, and I can give a short story. The reason we are so dysfunctional with CMOs is that the first local CMO was, I think, suggested in the 60s because the artists already knew about it. But remember that we didn't have a law that allowed any of this work. So eventually, Daudi Kabaka, Kasanga, guys from the Mushrooms, a bunch of artists come together and make the Music Corporate Society of Kenya. They founded it in 1984.
The artists themselves?
The artists themselves. So it was founded by the artists themselves in 1984. But there's no law to support its work or the collection of its work until 2001. And so by the time we're getting into the regulation of collective management societies, which doesn't come until 2011, basically MCSK has existed for 30 years, close to. So now private sector, CMO being private sector, is 30 years ahead of regulation. And so the laws and also the regulator has struggled to handle this situation because by the time we're dealing with MCSK, by the time Sauti Sol is joining, or even myself when I'm joining around 2011, MCSK was no longer a CMO, it was a political organization. And so it had all the hallmarks of the drama. And so the engagement right now is that currently the legal situation is that the licensed CMOs in Kenya are two. It's CAMP and an entity called PavRisk. So currently that's how. So how artists work.
What's CAMP in full?
CAMP is Kenya Association of Music Producers. And then PavRisk is Performance and Visual Rights. Something RSK, yeah.
So that's the artist and the production side of things. That's what I'm understanding.
Yes.
For CAMP and PavRisk.
Yes.
The performer and the producer.
The performer and the producer of the art.
But for PavRisk, they currently also collect on behalf of authors. Yeah.
So it's both sides of that entire operation. Meran, what does that period of limbo where no one knows what to do, there's no legislation, what does that do to artists at that time?
I'd like to give an example. Before I was a writer, I've listed filmmaker as one of the things that I do. I was in the film industry. And in the film industry, roles kind of change all the time. You do this, you get an interest in this, you switch up. So I was a makeup artist once, and then I was a costume designer. So recently I saw a film I did when I was a student. It was in discussion. It was in a festival somewhere. And I just happened to see like the advert on IG will be discussing this in this film. I never signed anything. I have no rights to the film because I didn't sign anything. So then I didn't know anything about owning rights to this, or this is your intellectual work, this is your intellectual property. So now at this age when I'm way evolved in the industry, that's when I know that I needed to have signed something then. If the film is in discussion now, I'd have benefited from it being in discussion. So we're just trying to all catch up, as he said. If the artists are way 30 years ahead of the law, we're all just trying to play catch up.
We're just trying to play catch up.
Yeah.
What does that do to an artist, Moriasi, in the situation when Meran's art is being used and she has no control over it and has no profit from it?
It means to get to where you need to be in terms of your success, you're taking the stairs. Sometimes you might be climbing outside the building. You're scaling the building from the outside. The thing is, we're playing in we're competing against forces, not dark forces. So we're competing against other markets that are light years ahead of us. The artists, us, we could be light years ahead of, we could be at the same level in terms of information, understanding, songwriting, production, filmmaking, technology, gear. But if our policy, in our policy framework does not support what we're doing, we're going to be 10 years behind, 20 years behind, 30 years behind. And it shows on the continent.
It shows.
Right? So I'll give you an example. Because South Africa has been intentional, let me say, not the best, but intentional in what they're doing. I think IFPI put out a report, was it last week or the week before, that they account for 88% of all the recorded music income on the continent. It's 78 or 88%, which means then, because of how they're organized, right? Yes, we're generating, $150 million a year, but most of that is, it's clear that they're the ones who are collecting simply because they have the structures, right? So it has meant that artists cannot live how they're supposed to be living. So your hard work equates to maybe a fifth of what your lifestyle should be, who you can support, what you can build. The ecosystem, building an ecosystem shouldn't take as long as it does if you become successful.
If you become successful. And it means also that artists have to have another gig on the side of the actual job that they want to do because it's not sustaining enough.
I think to add on to that, one of the cases that we cite now as precedent for the incoming bill, the person who filed the claim is a non-Kenyan, I think a Nigerian, in the case with Nonini and etc. So saying we have to have the supporting structures is so important, because even one of the cases that we cite now isn't self-originated, it's from outside.
It's from outside.
Yeah,
Nonini, familiar name.
The Nigerian producer.
There's a guy who sued someone for using their, I think, song in a TikTok, TikTok adverts and things like that.
Was that
Nigerian producer?
So there are two cases. Nonini sued, and then there's a Nigerian producer who sued Nyashinsky.
Yeah.
That case was big.
Case, But he's based here.
The Nigerian artist is based here.
Still, he had to have taken expertise from his country to know that he can sue for his revenue. That's what I mean.
Is that part of the reason the Nigerian music industry and the Tanzanian music industries are light years ahead of Kenya's?
Are they light years?
They're not.
They're not light years ahead of Kenya. It feels like that.
No. What
is that how it looks on the outside?
Yeah. I mean, but what they have is Nigeria has a system of exporting their sounds. And once an artist has some, fire under their feet, they have a way of supporting their own, right? It's the same with Tanzania, but Tanzania is just one person. I think just our challenge is Nigeria also has output. They output
a lot of output.
So much music.
It's a new song
so we also need to be in that position. But we're not going to get there unless we're right. But also legally, we are light years.
We are light years.
Do you think so?
You wanted to say something?
Tanzania?
I can just clarify. We are light years ahead. You see, even the case that we are citing here, that case is not possible in either of those countries.
Really?
It's impossible.
Have you ever heard of a corporate adjudicated case in Nigeria? Never.
No.
So that case is only possible in Kenya, and also because copyright is territorial. That song was made in Kenya, so its copyright is held here. So he could sue here. It's not possible for him to do it. What he brought, I think, is the audacity and the feeling that he could sue, which I think is really good, because I feel like every artist should have the confidence to push for what you feel you own. I think it's really important, and I think it helps us. And I think Moriasi has covered the idea of the two industries. The other thing that I think maybe to add, just Dan Aceda opinion on this, is that marketing can make things seem like they're not. Overall, we have a more healthy industry of the countries that you've mentioned, but they have a bigger top layer. So their top layer has more artists, more output, and more revenue than anybody else. So we only know the top layer of artists from those countries. But Kenya, the industry is deeper than those places, with the exception of South Africa. That's my opinion.
Oh, you want to say something?
Yeah, and you see, where there's no law, there are the courts. And our courts have, over the years, been receptive, especially to, let's say, copyright matters. So they haven't shied away from trying to resolve those things. Like, there's the matter with MCSK, there's the matter with the two Nonini matter. It has set precedent, and the law wasn't really going to cover it, right? And whereas in Tanzania, it was just one matter. Most recent was AY and
Tigo.
They got a big payout, a huge payout, big payday
from a corporate.
Yes, can't remember what it exactly was, which corporate. It was either a bank or a telco. But you can see our precedent has been rolling. So the courts have been there to kind of cover the gap over the years. But what the proposed bill does is it now makes even the court's decisions a lot
easier.
Yeah.
Dance. Yeah, you want to say something?
Tanzania has more of a regulatory framework rather than to encourage them to earn from it, because they have a censorship board that looks at the lyrics and
before you put out a song?
Yes, they can ban your song when it's out, etc. So as to looking at what frameworks they have, I saw more of a regulatory side than something they can earn from. Yeah.
All right. Dan, now let's get to the flesh of this conversation.
Yeah.
Right? What does that bill that you're holding there do?
So there's a few things that are really important, and I'll go to what Moriasi was talking about first. Adjudication of copyright. The courts have been doing their best to try and help us solve our problems. In fact, just 2 or 3 months ago, an artist won a case against CITAM. She sued CITAM for them, Crisis the Answer Ministries. They re-recorded one of her songs and included it in a song that they then produced and put on YouTube, and she said they were making money, and she won that case. So courts have been really, I think the word that Moriasi said is they haven't shied away, which I think is good. But we've not set that up properly, because again, the law is outdated. So now in this law, what we've done now is to have the corporate tribunal have a lot more power around the adjudication of corporate disputes, which is going to bring it to like other industries. For instance, if you go to tax, if you have a problem with tax, you can go to the tax tribunal.
Yes.
Which is your first port of call before you go eventually to High Court. But it gives you a decision faster. It gives you at a lower price, right, than you'd get if you go directly to court. And also, it puts you with experts, so that your matter is first dealt with people who already know a lot about your subject matter.
Yeah.
So now with this law, we're going to make the corporate tribunal be able to take a case from anybody in the Republic of Kenya, as long as it's a copyright matter.
So now for the case of Nonini, it would be the copyright tribunal that.
Correct. That would be the first place. Of course, a person is free to go wherever they want to get justice. But the tribunal is your first port of call, because it's cheaper and it's faster. Because you get your decision, I think, in 6 months. I think tribunals try to give you a decision really quickly. So that means that if you're winning something, you get your decision earlier, right? And then the other party can appeal if they want. Other than this process at the High Court, where it's 5 years or 6 years, it's just slower. So that's a huge thing that's going to be very helpful. The other parts of this law that I would just like to clarify is the law is proposing to clarify some of the things that currently are copyright infringement because they were never covered in the previous law. And now we are trying to create some a legal framework for people to use content where they're using it fairly. So there's a new fair use, fair dealing section, which didn't exist before.
Yeah.
And importantly, for instance, if you're teaching songs to primary school kids, at the moment that's infringement if they're playing it. Because it's not their song. So
What song are you talking about? The hymns, the like nursery rhymes and stuff like that.
So if you're preparing a type of event,
festivals.
drama fest, whatever,
Yeah.
and somebody's song and you use it and you kind of use it in a different way and you modify
Oh,
it
yeah,
because
I
of part of
see.
it, that's infringement currently.
Yeah.
But we also understand it's in the educational sector, so there needs to be
And it's
exemptions
cultural.
for educational
Content,
purposes.
yeah,
So
purposes, yeah.
the bill has included those types of exemptions, which just helps to decriminalize some of the work that we're already doing and that everybody agrees is fair use of music. So I think that's really helpful. Also, the old law, because written such a long time ago and there have been so many ways to try to amend it, it's been hard to follow. So if you read the current law, it's really hard to follow the way we define things. It's just a hard law to understand. So it was very complex. Yeah. Now with the bill, the team has tried to make sure that's clear and you can understand. And then of course, there's a lot more clarity in terms of how we will manage collective management organizations, which has been put with a lot more clarity, also with the benefit of experience of the last 15 years. And now it's also being brought up to standard with international treaties. I'll add one more thing. For a long time, Kenya had been a signatory to a treaty which IP lawyers call the Marrakesh Treaty, which was the big part of the Marrakesh Treaty was to allow translations into Braille or into other languages that people living with disability can access. Currently, that's copyright infringement if you translate somebody's work. But now in the law, we are saying, no, there's exemptions if you're making the music accessible to, let's say if somebody has written a play and we want to teach it to a person who's blind, we need to translate it to Braille.
Oh, I see.
So we are now allowing that in a legal exemption. So then that's going to be easy. So off the top of my head, those are the ones that I think are really important.
Are important. But you mentioned collective management organizations. I'd like to ask Meran before I go to Moriasi, how much of a problem is politicization of such organizations that are crucial, like FAVRISC and MCSK?
Okay. Personally, first, I feel like we should have had we should have figured out the agency situation first before going to the BIM. Because currently we don't know who collects, who license, who. There's been kuna msuko-suko, like some people were banned, then they were reinstated, and then this happened, and then that happened. So it's really not clear to an artist like myself who I should approach for this or that. Like I feel like this part should have been made clear first before we attempted to make a new law. So they play a huge part because they're the ones who are supposed to advocate on behalf of artists because they are a collective body. So I feel like that should have been done first to strengthen the collective bodies before going to
actually legislation. Do you agree with that, Moriasi?
I think they should happen at the same time. But to be honest, the statute needs to come before the agency, because what this law does is that it creates strictly enforceable guidelines on how MCSK will function. Whereas, let's say the 30% with the current bill is more of a suggestion, now is law, right? So there won't be any, you spent over 30%, but it's not our fault, but now it's in the law, right? The law is the law. And the one thing that, and I think the younger generation has shown us, is that there are some things which are going to be non-negotiable. And now the law is one of them. So with this, it will help. Yes, and what the proposed bill has done is that now there's going to be an authority rather than just a board. So it will help as well. So what the authority will help us do is build more enforceable regulations rather than just policies. And what that eventually will do is that it will grow. right?
That's the Copyright Authority you're speaking.
Yes, the Copyright Authority. And the other part of this is that I think the regulators should be run by professionals, right? And with this new law, and I really commend what Akina Dan have done, because now anyone who's going to be part of the authority must have some form of engagement with IP, the business of the arts, IP within the arts, the business, or the financial side of it. So what then we eliminate is wazees in three-piece suits, chilling, and the future Dan Aceda will have an easier time
dealing with
to amend this bill.
Yeah.
Because Dan, I'm wondering how he still has dread.
for Kwana balls.
He has black hair. Me, I have white hair. I'm younger.
I would want to ask in that case then, because one of the things I'd look at, if you guys say that the bill will regulate this and that, yeah, like MCSK at some point said we collected this amount, then you guys, Kekobo, said no, you guys didn't collect that amount, you collected more. Right. What exactly is in the bill that will govern such kind of things? Yeah.
This is my moment. This is my big moment.
The time to shine.
Come in.
I've taken over.
So first of
your
all, over the last 2 years, I know that this is my 8th month at the board, so I haven't
Why,
been there
already
that
a
long.
bill, eh? You're working hard.
Yeah,
Track record,
so a lot of good work had been
Chapa
done
kazi.
before we got there, but then we were able to push it through. But the last 2 years, we've tried to stabilize the sector for CMO sectors. So there's 2 CMOs, and that's how it's been. The people that were rogue kabisa did not license them and took them out. And they've lost every case that they have filed against the board. That's MCSK. Okay. And they will continue to lose because we took the initiative. The entire board was very well. We were all agreed that we have to do this right and we have to do this well. And so we made sure that the process was followed to the T. And remember, we don't owe anybody a license, we just owe you fairness. So we made sure that it was a fair process. And in the fair process, they didn't meet the standard. So now we've got just the 2. So the last 2 years, that's been a settled thing. Some of the gaps that have been there with CMO collections is that there hasn't been, remember 2001, this idea of even collective management was not part of their thinking when they were writing the law. So they began to do CMO regulation in 2011, 10 years after the bill, and they were trying to put it together. And so the challenge also they had was that they had a very old organization that was set in its ways. So trying to solve for that was difficult. And so, for instance, the board in the current law, the regulator can only do one of 2 things, well, maybe 3. They can register a CMO or they can deregister a CMO. That's it. The third one is fuzzy. It's section 46. It's like, you can inspect the CMO, but it doesn't really say what you can do. So there wasn't a lot of legal muscle given to the regulator under the current law. And so it was left to the artists themselves to manage it for themselves. But that's difficult, right? Because of how the infrastructure was set up. So now when we're moving over to the authority, there is much stronger legal statutory authority given to the authority to be able to inspect the books of accounts, to be able even to shift the work of one CMO to another one in case of failure and insolvency, to be able to show up to the authority and hopefully even be able to enforce things like distribution, royalties to artists, which were not happening, and which the current law has no way for the regulator to enforce royalties. Some things are so simple, but I remember asking colleagues when I first met them when they were writing the board, there's no requirement for the CMO to be tax compliant. Did you know that? There's no requirement. It was never written in the law. So we are hoping that other parts of the law can be helpful in this, but in the actual regulation, it was never there. So now in the new one, these are things we're deliberately saying, okay, you have to be an organization of good standing before we can even consider you, right? So you've got to clear with KRA and other relevant agencies. And so stuff like that, I think, is going to be a game changer. Modeling this also around what they do for the insurance regulatory authority, where you can see even the last 2 weeks, the regulatory authority moved in and took control of 2 insurance companies, and they're trying to protect the policyholders, or protect the employees. That's the type of regulation we're looking to get, where it's more proactive and can do things without necessarily having to wait until the end of the year.
The gray areas were why I brought up strengthening the institutions. But if you say that that is covered in the law, or the regulatory body will be more stringent on that, then
It answers your question.
Yeah.
There's this question of corruption in the particularly MCSK.
Yeah.
Corruption. I remember this scam cardinali line ya usiniulize mbona nakuibia jumuibia na MCSK.
Yeah.
You know that line. How big is that problem, Moriasi?
It's big. It's been a thorn in the side of wasanii for a very long time. And not just wasanii wa chini, wasanii wa River Road, wasanii wa mashinani. Sisi, you know, our music was irregularly licensed to a political party a few years ago. And when we tried to move legally, you know, the then head of MCSK said we didn't even understand our own rights on TV.
That's what he said.
Yeah. Then what was his name? Ezekiel Mutua.
Yeah.
He said we don't know what we're talking about. They have the authority, and
they have the authority. That's MCSK,
but it wasn't within the articles of association. Actually, it's against the articles of association. What they did was against the articles of association. We had done the research, and that's how we had presented to the lawyers then for the said political party. And we were getting to where we needed to go in terms of that negotiation. And then we broke it up. But corruption is a big issue. I think over the years, if I would be wrong, it could be more than 20 billion has been collected.
Yeah.
20 billion.
I think less than 100 million has been distributed.
Where does all that money go?
Administrative costs.
That's to pay the board, allowances here and there.
I guess that's what they put on their books. But the reality is, if it was regulated better from the beginning, then it would have happened. But again, it's a lot of money. But also, I wouldn't say it's just the corruption, but you know, so corruption is oversight. And for a long time, it was very few artists who were fighting that fight. It was done, I remember there's a time we went to Macha.
Yeah.
And the MCSK director didn't come.
They didn't show
up.
What was happening?
No, it was AGM. And they knew, like, so there's a generation that came, Dan, Calvo Mistari, Nons, DNA. There was that generation that are going to now asking for accountability. Yeah. And these guys were told, if you're coming to Macha, mkuje na accounts to PTA, to ONE. And they didn't come.
And nothing was done after that?
I think a few years later, we went to court. I remember who were part of that matter. We were fighting MCSK on a couple of things. We even used one of our lawyers to fight that matter. But it's a long thing because, again, like Dan said, the courts really tried their best. Yeah. Because you go in front of a magistrate. And that time there was a constitutional petition filed in front of Justice Lenaola. And he used to say in court, guys, I have read about this thing for the last 2 weeks. I'm still fuzzy on,
it's
so please,
me.
counsels, take me through this. Right? Even in one of the matters that we have now, the magistrate is very patient and she keeps on taking us back when someone says a technical term on the copyright side. She always takes us back and says, okay, now, counsel, explain that granularly, like break it down.
Yeah, break it down.
Right? So they've tried their best. And I'll be honest, they've tried their best. It's an area of law that took a long time to develop in the West. Yeah. And the West in my opinion, wanted to keep it for themselves. Right? So if you listen to someone who's in the copyright space in the US speaking, and someone who's from like Kenya, this person will speak and then Dan will break it down so easily, but this guy has used 12 paragraphs, Dan Aceda.
Deleted
Simple,
terms
simple,
to confuse you.
Yeah. So this is a protectionist element to it.
Mm.
So the corruption has cost this industry a lot of
A
money.
lot of money. I can imagine that. And how aware are artists about this, Dan?
Awareness is low. It's very low. I think that there's two things. There's the feeling that I'm being robbed, which we hear in the music. And the artists know that they're being robbed.
Yeah.
But they don't understand how and why they're being robbed. And that's been a big issue. So even the latest victories that we've had, against a legacy organization like MCSK, against the type of operation that they are doing, this is the first year that the board or the regulator stepped in to censure them, and the artists have not protested against the regulator. This is the first time.
Yeah.
So the time me have been involved, I've always been going against artists, fellow artists telling me, what am I doing? When I sued MCSK, I think 2017, 16, the people threatening my life were fellow artists. They're not, they're not like old guys in the suits.
Why so?
Because what MCSK managed to do, and I told you, become a political organization.
Yeah.
So over time, you develop these structures and this way of working. So they were cash rich, very low accountability and cash rich. So when there's a problem somewhere, what do? Pay this guy to pay this guy. So it was easy to organize groups of people to advocate for things that were in their worst interest. But they, it's hard for them to say. So awareness has been an issue. I think, like I said, great recent victories, but it's a thing that we should still work on to help people understand where we are with things, and just to help people understand, also to learn to dream. Because what we want is also for people to dream, to take them. Listen, royalties are not supposed to be your primary revenue, but they are your long-term revenue. And it's important to think about that, right? People who played in bands in the 60s, 70s, 80s in the West, they still earn money from being a drummer on a gig, on a song in the 70s.
Yeah.
While here, that's not possible.
Yeah.
So, there's an active part of your song. When you're playing gigs and you're being booked and you're active. So there's active part to 5 to 10 years if you're really good.
In your prime, yeah.
Yeah. And then after that, nobody's booking you that much, right? If they're booking you, they're booking for lower fees. Now you rely on those publishing. And royalties. And that's what keeps you there. So that's what we've lost. And I think the numbers that Moriasi is talking about are probably realistic.
Yeah.
The highest collection in Kenya that's been recorded, if I remember, was maybe mid-2000s. MCSK collected 500 and something million. But they didn't distribute nearly what they should be.
Okay, I'll answer as an artist. As someone who's currently I'm working on 24 Birds, the research team, and we have writers and we have people on stage. Like, there's a huge team, and everyone gets a contract before they start the work. My work starts way before the guys get on stage, So it's only just now that I'm reading through the fine print and trying to figure out, like, okay, as a researcher, what does this mean for me? What they've written here? If they say that 2 Birds owns every reproduction of this, it means every time it goes into reproduction, they will earn money for it, but I won't, because I have signed away my rights. Or if they say every time it goes into reproduction, we'll give you X, you can earn these royalties. I learned about residuals from watching TV and not anywhere else. Like, seeing Americans get a check that every time your show is played somewhere, you get a check. So there's more education to be done. I don't know by who. I don't know if it's Kina Dan, but there's more education to be done in all spheres of the industry.
If you pass this bill, there's a section specifically on that.
There's a legislation on that specifically.
Specifically on education and capacity building on the industry, specifically, which is regional first, by the way.
Because you see, like, writers are being left behind in the conversation.
Yeah.
The one regulatory body that I think writers can say they have is the Writers Guild. And even this, writers don't know about. And writers in the past fought against this by, I think Binyavanga Wanaina founded Kwani, and having those groups where people can converge and share ideas is what led to more education. So again, we are starting anew, I think so. Yeah. So there's more to be done. Done.
Absolutely.
That's what
That
we
rhymed,
done.
yeah. I have to give it to her.
Absolutely.
But I think also it's about challenging.
Pay artist K, sorry.
It's about challenging the individuals who have the resources and the knowledge to start prioritizing education as much as they prioritize eventing, or as much as they prioritize monetization of their own work, right? So, like with what Mudon is doing, she has a big priority on education. What we do with Press Play, our artist development initiative, you can see a corporate like Tusker has integrated some of the things Mudoni and I have done, and Udoni and us have done, and now they're moving on that as well.
Yeah.
But within the filmmaking space, and I'm challenging Toshki Tonga now. Do you have a program that will help young filmmakers build the business side of things, help them understand what it takes? Right?
That's important.
Yeah, and it's important. You guys here, do you have that as well? Like, even if it's just once a month, guys, I think it's important for us to really prioritize the education side of things and let people know. Let's not leave it to government, because I'm not pointing at Dan saying he's not Gava.
Yeah.
I saw you do that when you were saying.
No, but yes, it will be legislated, but as private sector, as people who have suffered,
Yeah.
we should be the ones
The
to
ones
have those
to-
conversations.
Absolutely.
And let's come together and have, there are spaces that are dedicated to helping those conversations happen, like Baraza Media Lab. And now they're building other spaces. I'm sure they're building Kisumu.
Yeah. Kisumu
There is a
complete,
Baraza Lab Kisumu.
There's a Baraza in
There's
Coastal.
a Baraza Lab Nakuru.
So it's about us also having those conversations with the team at Baraza. And can we start these initiatives and start moving those things around? In urban space.
Done. AI is a big thing right
Yeah.
now. It's making music. It's also being used to teach models out there. Does your bill, does it incorporate all those things and protect artists from those threats?
I like that you're calling it my bill. So I'll say our.
Well, your bill with Kekobo.
Yeah, so I think that there's, I agree with you. I think AI is going to be an interesting, complicated challenge now and in the future.
Yeah.
So first of all, I'll clarify, the way that we are looking at it is, and even though the bill is written, is that only a natural person can own copyright. So a machine cannot own copyright. So nobody should be afraid of AI owning any copyright. Section 17 of this defines what copyright is, and it allows a natural person to make use of any tool to make AI. So you can use it to make something which then can be copyrighted.
It can be copyrighted.
Which is standard in terms of the practice, how the practice is, I think the US is moving towards that, where you allow a human being to use whatever tool they want and they can make the copyrightable material. There's one section which I think everybody has been talking about, which is section 34, where we are trying to fix, the goal was to try and fix exemptions where people are doing research. And so there's a line there that says, copyright is not infringed by making a copy of a work for computational analysis or for non-commercial research. Yeah?
Non-commercial is important.
Research, yeah. And then there is we provide that A, the person has to have lawful access, so you have to have a license. And then B, that you also have to acknowledge that you have used somebody's work. And I think the feedback we've got from this section is that we're not going far enough in restricting what AI companies can do. Yeah. And I think that feedback can be taken. And I know that the team is working on a rewrite to strengthen this section. Yeah. But like I've read it, the way it was written was assuming that other checks and balances would already be taken before the AI LLMs are applied to anybody's work. So, and this is specifically important for people in literature. Yes. People writing plays, books, because that's a huge part where AI is infringing on their copyright.
Some of them have been used. I imagine Swahili books must have been used by companies to build models.
Absolutely. And so remember, right now we have nothing. Right now we have no law. It's not as strong, as this would help us have more clarity. Yeah. I do want to also say, artists in Germany have just won a case late last year against OpenAI. And the settlement here is in the region of hundreds of millions of dollars, where the OpenAI was caught using German music to teach language to their LLM. And so an artist group sued, class action
They
suit.
won.
They won, I think, $500 million. Don't quote me, but I think that's what they want. So again, it goes to tell you that where you have the law, where you have prescriptive, and you have a lot more strengthening of the structure, as Moriasi was saying earlier, it gives the artist a lot more impetus to attack an issue. So like right now, even things like Anton Pillar orders, which is the order for you to give us information that you hold about things, that didn't exist in the existing Copyright Act. So that's coming in the bill. So like now it will be important. A judge can say, Sawa, since we don't know, bring all the information you have about how you trained your AI. And that would help you figure out whether your stuff has been used there, right? So that's the way we are approaching. Like I said, I think there's been feedback on how to rewrite Section 34. And I think the team is working on that draft. So hopefully that's something that will be resolved. But we can't solve the whole AI thing on copyright. It has to be solved elsewhere. What we can do is try to protect how AI operates in copyright.
You have something there?
For AI, I think that's also the onus is on the artist, because when you feed your work into the system, you cannot again complain about how the system uses your work. There's been debate online about someone, I think we're just starting to have these conversations about someone's music being AI, a Kenyan. And so I went to check, like, what does the AI model say about this person's work? So if you're a premium user and you create music with whatever LLM or whatever, the music belongs to you. But if you're a non-premium user and you use whatever to come up with music, the lyrics are yours. Whatever you fed into the AI are yours. But whatever they come up with at the end is not yours.
Say that again.
I'll go again. If you use AI to create music, like Sumo, I think Sumo is what is most popular for this. Suno, Suno. Suno AI.
I've seen that.
Yes. So if you use Suno AI to make your music and you're a premium subscriber, everything that you have made on Suno is your own. But if you use Suno to make music and you are not a premium subscriber, you own just what you fed into Suno. Whatever they gave you back is not your own.
They have a percentage of what they gave you
so
back.
It is not, you don't have ownership of it. Yes. So that is on the artist. I think you have to figure out whether you want to be an AI artist or not. And I don't think, this is a personal opinion, because we haven't regulated AI in itself, just beyond using it for art in itself, we haven't regulated AI. I think it would be quite a gray area already using it for art if we haven't regulated it.
If you haven't regulated it.
It's an important point she's raising, because right now people are being sued. So, what Suno is saying is that, you indemnify us for whatever you've done on this platform. So now, I think Sony has made an AI reverse engineering tool. So you can put anybody's song and reverse engineer, and it will kind of say what songs were referenced to make this. So people are beginning to sue the AI artists, which is happening in New York. Very interesting stuff. So I'm really looking forward to that kind of stuff. I can't wait for those lawsuits to
come here.
Yeah, I think it's going to be, incidentally, this thing that's happening in the world has always happened to people in Africa. Like Moriasi said earlier, the global north has always acted as if their copyright matters than everybody else's copyright. So for instance, the mushrooms have a legitimate case for Jambo Bwana and how it was used in Lion King. Legitimate case. Never been able to prosecute it, but legitimate case.
Does it apply, what's it called? Does it apply retroactively?
I think you can sue whenever you are ready to sue.
Wait, because Lion King has just sued someone for using Lion King the wrong way. So
the writer sued for defamation.
So if you said the mushrooms have legal claim,
Jambo Bwana and all that, there's elements of that in the Lion King music.
Lion King
and
music,
I think they are well within their rights to sue. And I don't know why they haven't, but I would sue in Kenya actually, because here the law protects you more.
And you have something to say about that, Moriasi?
No, not about that. Also, we know how Americans operate, right? You sue them, then they get the hardest hitting big law firm
to come after
New
you.
York law firm, which has 10,000 lawyers across the world
with influence.
But then again, it takes someone to try and get it done. The small fish have won over big fish over a period of years. It eventually happens. In the tobacco industry was sued and someone won. if the pharmaceutical industry was sued and someone won. It's about time especially on this side of the continent, we take that initiative, right? Yeah.
And on I'll stay with you, Moriasi, on this one. There's specifically and that bill creates space for collateral in intellectual property to be used. Is that correct?
Yes.
How does that affect an artist?
So I'll give a number of examples before I come to what the question you've asked. It'll help answer that question, right? So in the US, there's something called Bowie bonds. So what happened was there was a conversation around why can't an artist who's earning an insane amount of royalties just go to a bank and get a loan? So there was, I think Dan can break it down a bit more. There's David Bowie managed to do it, and what that president said was that his royalties were how the valuation was done on the amount of money that he could take out was 10 years of the value of the royalty, right? So that happens there. That's in the US. There are two sets of legislation that allow for that. In the UK, it happens as well. In South Korea, it happens as well, right? So what has happened is that those areas or those spaces for artists who have or creators who have a form of IP that allows them, that you can show has regular income, quarterly, half year, end of the year, and then you can securitize that, right? So in what the bill has done is that now it has forced banks to now go back to the drawing board when it comes to this especially. The bill sets up a national rights registry. This registry, the same as the lands registry, right? But electronic, same to is we a green card, come a title deed. So it's an electronic rights registry that the banks will be able to access. Now, what the banks have been forced to do by this act, no, let me not say forced, what they've been required to do by that is to go back and find a way of scoring royalties. Right, for facilities.
Okay.
There are 3 young ladies, in fact, I had a conversation with last year. They've built a tool that helps score music royalties. 2 are AI engineers, and then 1 is a UX UI designer. So I mean, if there are people like that, or the thing about Kenya is there's so much resource. You just need to find out what some of these the young kids are doing. But, if they can get in touch with these ladies and, they'll help them build the system. Because the people have been thinking about this already. Yeah. So that's what this bill does. Then what that does is, and I'll tell you what it means for us as Soul Group, because we're 6 businesses, right? There's entertainment, there's Soul Generation, the record label. We have Soul Generation distribution, publishing and distribution. We have Soulfest, and we have Press Play. Our dream is to build something called the House of Soul.
House of Soul.
The House of Soul. If you can get 10 acres of land somewhere, if that land costs 100 million, our royalty collections, we can get our royalty collections scored, go to the bank, we deposit all our IP or the IP at that value within the bank, and by that time, then we'll have a 15,000-seater capacity venue. It'll have Press Play as an academy. It'll have recording studios, have these kinds of studios, it'll have all these things. And then what that also does is that we'll have some money on the side to now market the way Nigerian artists market music, because it's all about marketing. The best example I can give you, when this legislation like this passed in Korea, right? It was passed to support the export of culture through K-pop. And look at where K-pop is now. It's a global industry that contributes back into the economy at the same rate that industry in South Korea. So at the same rate that Samsung, Kia is bringing money into Korea, K-pop is bringing the same amount of money. Right? So that's what it can do for this market. Also, it can do for artists, and also I think it will help the banks because it opens up there'll be a new race for youth banking in this country, the reality is a lot of banks have looked away from the youth and have said,
yes.
but we're going to be, I think, in a good position, and I think it's very important what they've done.
Yeah.
It's extremely important.
It
So
is,
thank
it
you
is.
again.
No, Karibu, Section 61. That's the one for that. And
For
I
the
think it's
collateral
important
thing.
because what the bill does is it doesn't create that business, but it creates a recognition of that business. So then there'll be actuaries and whoever who will come and calculate what your IP is worth. And think about it. Look, if you have a clean system, an artist should be able to, even if circles are doing 3 times, right? 3 times what you have will give you as a general rule of thumb. Yeah, imagine that an artist,
For an artist, it
time,
could change something.
it could do a lot. It
Yeah.
could do quite a lot for a person long term. Yeah.
And especially someone who's, let's just give an example. Bien is now on a global trajectory, right? If he breaks in the US, the valuation of his publishing alone should jump 20x in this market.
Yeah.
So he might have taken money out by NCBA, but then by the time that, or KCB, or and we bank with KCB, just say. So challenge KCB. But if he breaks at that point, right, then he's starting to play arenas in the US and arenas in Europe, right? That means his IP is now skyrocketing. It's skyrocketing. And at that point, then he's probably doing a daily return. Remember, it's a daily calculation. Because once you hit a market and then you start blowing up, your streaming goes up. So you go 2 million, 3 million monthly listeners, 10 million monthly listeners. You keep going and going and going. And then if you get into the US market, the return on that monthly listener is higher than Kenya.
The one here.
If you're in Europe, if you're in Germany, it starts growing.
Yes.
So you might even 20x, 30x.
Yeah.
Right? And that it shows you why investment firms like BlackRock are buying up
A lot of record labels.
No, they're buying up old performing
IP rights.
catalogs.
Or
Oh
IP
yeah,
rights,
like buying up a catalog of an artist. Or
So yeah, and it also shows you that Michael Jackson was 50 years ahead of his time because he kept his publishing and said, my family won't go broke because this music that I've made will always make money.
You'll always make money.
And they can always borrow and borrow, because if your catalog is making $100 million a year, you can borrow. If you're saying 10x, that's $1 billion, right?
Yeah.
You're good.
Imagine.
You're good. And Dan, there's a question here. So we polled our audience and asked them, as a member of the board shaping the 2026 copyright bill, what is the number one question you want Dan Aceda to answer tonight? 40% of them said art as loan collateral, which is exactly what you both addressed. 20% said solving MCSK CMOS scandals. That's something we've spoken at length about. The third was protecting copyrights, and 40% have said that they think this is the important question to ask. And some say that the state of AI in art is important to address. I'd like for us to close with the protecting copyrights bit, because at the center of this is percentages. Kendrick Lamar says, let's speak on percentages. Show me your splits, right? What does this bill do to percentages?
No, there's not much change in terms of percentages, because percentages are decided by the artist in the recording room. So what Kendrick is talking about is the splits.
The splits with
The
production.
splits,
Yeah.
he's talking about a split sheet, where if we were in a studio today making music, and I was a producer and you are the songwriter and you're the performer, and you added, you're singing like the bridge or something, we need to agree who owns what. But that agreement has to be done in the room.
When you're producing the music.
Yeah, the best practice is you agree in
Before
the room.
record.
Before mtoke. No, after you record.
After you record,
because it depends on, you measure it depending on what somebody
contribution.
contributed, But it's very important that you agree in that room before you leave. The initiative we're trying to do is not, well, it's still ongoing right now because it doesn't need a new law. But it's that we're trying to educate two things. Educate artists on how important it is to do your splits in the room and get sign-offs from everybody. And secondly, to have a better database capturing those splits, which is what the National Rights Registry is, to understand who owns what part of which song. So that in case there's a dispute in the future, 50 years later, you don't remember who sang the last line, and now we need the money.
Go back to the registry.
We can go back to registry and check, right? Okay, so how much do you own? Which is similar to like business owners. You own specific shares in specific companies. So we are trying to implement that type of thinking on the song or on any piece of work. So you wrote a book, you wrote a play, you did a film. It's important to write who owns what, and so that we understand who owns what, or at least somebody keeps a record of what you guys decided who owns. So that can help us for future disputes, and also can assist in terms of measuring the value of the work later. So the bill, it's important to say, the bill is trying to solve the structural issues that we have experienced coming up in the industry and that we can see right now. But the actual work of building music businesses, of building creative businesses of any kind, that has to be done by the creators. And it's important that they understand that that's the role for you. What this bill is trying to do is to draw for you the field of play and put a referee. So this is the field and this is the ref. You have to kick that ball in the goal. It's you to win that trophy yourself. And it's important that they understand that. So it won't be that. Of course, there are parts in the bill where we are trying to do affirmative action situations, where we are saying an artist who's coming up in Mandera or is coming up even in Uko Kwetu, Vihiga, these places, is having a harder journey than an artist who's coming up in Nairobi. And we understand that. So there has to be some things that the bill will try to do, which is what we're trying to do by suggesting that the authority can give people grants, which is like to say, we'll recognize that there are some parts of Kenya where it's hard to create. We give you a grant for you to create, to make that creation. But even with that, I can't understate this. I can't underscore this more. The artists have still got to do the actual art and the actual art business. What we hope to achieve with this bill is to solve a better playing field. And remember, I'm in the board now. I'm not going to be here forever. There'll be another person in this role. Who knows? The way I talk, maybe next week.
Someone else with a different sound will.
But the idea is, while we've got the energy, to invest in a law that can help us all.
Yeah, we do it. No, the creation is Moriasi's side of the business, which is a great place to end it. Dan, asante sana for coming to the show. Meran, I deeply appreciate you showing up. Moriasi, asante sana kwa kuja, man.
Thank you.
You guys were enlightening to just listen to the whole time. So asanteni.
Thank you.
We'll close this today's show with our usual public participation, but this time will be different. So Africa Uncensored and some creators, some tech geeks came up with a tool that is supposed to fuel your registration to be a voter. Tukokadi is a huge conversation in the country right now. Thousands are registering every day to vote in next year's election. Africa Uncensored created a tool to automate your knowledge of the polling stations near you. So you do not have to go to the IEBC website. There's a tool that should be running on your screen right now where you can put your location and it will give you any registration centers that are within 5 kilometers of your current location. And apart from that, if you can't find your location within 5 kilometers, it allows you to extend to 8 or 10 kilometers radius around you. So with that, you should be able to see around 3 to 4 or even 5 registration centers near you. It's based on constituencies, which is what IEBC is doing right now before the mass registration kicks off. But this tool is something that can help you join the Tukokadi conversation. It should be on your screen right now. If it's not, go to Africa Uncensored's website and look for it. Go register to vote, participate, and let your voice be heard in the next election. That's all from us. Dan has been our guest. Meran has been our guest today. Moriasi as well. All three of them have contributed greatly to this conversation. We'll see where this bill goes. And maybe Dan will have you here next time. I hope that this goes through because it sounds like it's a good thing.
No, it will.
It is. Yeah, I hope.
Dan bash. Bash.
Mbaya bro. Kwanza utapata like 5% of the royalties. Mbaya sana manze.
Bash rules has to go.
Mnampea 5 minutes ndio.
Bash and the yake.
Yeye manzi around to show manzi.
Big show ndo akae hapo serve your food.
Pige show. Aende zote tatu si ndio? Asante sana Dan, asante Moriasi, Meran one more time. Thank you all for listening to this conversation. This will be available in podcast. I've been Tom Mukwana. Catch you on the next one.